Tennessee, come out and play.
This is it, Jennifer. Your big breaking TV.
Yo, what's poppin', Henny? Gang. Bar is open, y'all. I smell a debunking video coming on. Child. Least we not forget, this is Hennessy Reviews.
Not the prime time.
What's poppin', everybody? Welcome back to the bar. It's your girl Henny, and I'm about to pour plenty of the hot Henny that y'all love to sip on. So if you are new here, please be sure to like, comment, and of course subscribe. Click that notification bell, select all, so that you get notified whenever I do a video. And if you are a returning Mob Down Henny gang member, you better have your bell selected to all. And if you still not getting your notifications, check your phone settings. Make sure that you've got your phone settings set to YouTube notifications on, and then make sure your bell is selected to all so that you don't miss when I pour up the hot Henny live, because y'all be mad. But anyway, yeah. Now let's get into this hot Henny. So I have been on a little bit of a hiatus. And if you caught me the other day, I caught some bad juju off of somebody that was here. So let me just say this. Let me take my glasses off and let me just say this. If you don't like Henny, don't rock with Henny. Don't with Henny in any manner, shape, form, or capacity. Don't rock with the Henny gang. Don't like the content. Don't come over here. Because guess what? You ain't got to be here. Because there's a lot of people that like to be here. So don't come over here with your bad juju, okay? Anyway, back to the content. So, as y'all know, Diddy and Jay-Z were named in a Buzbee Jane Doe case. And Jay-Z and his Roc Nation legal team, they was going at it with Buzbee behind the scenes. Old girl got caught out there telling a couple of 2-3 things that was not true. Okay, I'm trying to be polite. I'm trying to be polite and not necessarily say she lying, but she got caught out there with a couple of things that was not true, okay? One of those things being that her father said he didn't remember. All right, now I was saying there's a possibility of this and a possibility of that, but let me be very clear because a lot of people were wrongfully accusing me of being on her side, okay? So let me explain this to you. I take a non-biased stance when it comes to, certain content and all of that. And I'm getting ready to take a non-biased stance with all of the content that I put out there. Because at the end of the day, I don't know it. I don't know you. But I was also questioning from the beginning, was Buzbee the one who put this girl up to this? Because she's autistic. And I'm not saying that autistic people can't devise a plan of their own and come up with anything on their own. I'm not saying that. I'm not saying that they're incapable. What I am going to say to you is, though, somebody put this lady up to this. And I question if Tony Buzbee had his hands in it. All right. Now, a lot of people have been online questioning also, was she paid off? Did she receive some type of settlement for her to zip it? Did she just give up because she, knew the jig was up? People ain't believing what I'm saying. So she backed away. But I still question who was behind all of this. So now here we have the court doc, okay? And in this document, this is where you see that, oh, wait a minute, I'm on the wrong doc. This one right here. It says notice of voluntary dismissal. So Jane Doe went up into court, and pursuant to Rule 41A, 1A(I) of the federal rules, she went ahead and voluntarily dismissed with prejudice her suit against defendant Bad Boy LLC. Okay. And this was, February 7th. And then yesterday on Valentine's Day, it was approved and gone through. And now what that means is she cannot go back. She can't ever bring this suit back up. So again, I'm curious as to why she let it go. I really am. I'm not going to lie to y'all. And I know before people start talking about, oh, but Henny, you was doing videos about a U-shaped driveway and all of that. That's because they were focusing on the house in the Hamptons. And the house in the Hamptons was not the only house that had U-shaped driveway. And being from New York, I know that it doesn't take but about 45 minutes to get from Radio City Music Hall to Westchester County, which is where Scarsdale was, and he had the Scarsdale house. Now, if you missed any of that, you can go back and catch that. I will be setting up my playlist, but y'all could go back and catch that, okay? And I want y'all to put a pin in that house just in case it comes up again, okay? All right. But now, remember, Roc Nation has a lawsuit against Tony Buzbee. This is the document right here. Okay, this is one of the documents. Sean Carter versus the Buzbee law firm. Anthony G. Buzbee. Okay, least we not forget that this is still out there. Okay, and this court date between Jay-Z and Buzbee is set for March 26, 2025. So this court doc, March 16, 2025 at 8:30. The case between Buzbee and Jay-Z Roc Nation is still there. It has not been removed from the docket. So their case is still going to continue on, and I'm going to be interested in seeing how this case actually plays out, because child, it's been a whole lot of going on. If you're just stepping in, hey y'all, hey, no need to wonder who we're talking about. If they're down at the bottom of the screen, this is who's over here on the screen. You know what I mean? Anyway, moving right along to the next case, because baby, let me see what y'all saying in the comments before we move on. Anybody got any questions, comments, or anything to say about that case before we move on? Let me get y'all Henny glasses up here on this chat, because baby, y'all already know what to do when y'all come rolling through. Throw them Henny glasses up in the chat. Hey, everybody, thank you so much for coming in. I appreciate all of you. Hey, Swaglow. Hey, LT. Hey, all of y'all. I'm looking for comments about this particular case before we move on, because I want to give y'all a chance to speak. I said somebody tapped dad on the shoulder. Okay, so that's an interesting theory, to think that dad was tapped on the shoulder and paid a bag to not recall the story. Okay, salute to I Got Five. Let's talk. Okay, her dad probably talked some sense into her, considering he didn't corroborate her story of picking her up. That's true. These are good theories that you guys have down here in the comment section. That's a possibility. All right, so there's not much more that y'all are talking about. So, child, now do y'all remember when I did the video on the game about Priscilla Rainey, the last video that I did? And I told y'all in that video that the game was trying to get the case dismissed and thrown out, okay? And his reason being was because there were clerical errors. But this is one of the documents right here, if you don't remember. He was saying that she had Santa Monica Courthouse, which is right here, this blue highlighted portion right here, that it was the wrong address, the wrong court. But this document was filed back in September 13th of 2021, right here, right there, right? And he was saying that she forgot to mention one of the defendants in this publication right here. And again, she had the wrong courthouse address in this publication. But this was from 2022, okay? And so here we are in 2025, and he filed suit to get the case dismissed. Well, they went to court yesterday, and baby, let me go on ahead and get my glasses out. And let's read the minutes from the court date. Wait a minute. This says January 30th. My bad. I said yesterday. I got it yesterday, but they was in court January 30th, 2025. Okay. All right. So for the plaintiff, there was someone there for her. And for the defendant, there was Sean Raymond Bozarth. That is his name. Okay. So there were people there representing. Okay. Now, what it says is a defendant may serve file a notice of motion for one or more of the following purposes: to quash service of summons on grounds of lack of jurisdiction of the court over him or her. A court lacks jurisdiction over a party if there has not been proper service of process. And that's what they were saying did not happen. Okay. When a motion to quash is properly brought, the burden of proof is placed upon the plaintiff to establish the facts of jurisdiction by preponderance of the evidence. All right. So that's what we're talking about legally. Right. So here's the analysis. Specially appearing defendant Jason Terrell Taylor. I'm not lying to y'all. Let me see if I could zoom this in for y'all to see for yourselves. No, y'all don't see for yourselves. Okay, you know what? I got to come off the screen and I got to show y'all. Let me see if y'all can see it if I do this. Can y'all see it better? Okay, y'all can see it better. All right. So if y'all are commenting, just know that I am not going to see. I already see y'all comments, but I'm not going to see it right now, because I'm not even on this screen. So I want y'all to look right here. Y'all think that I'm lying. This right here sounds like special guest star Jason Taylor, the game. I could make this up, but why? Okay, so specially appearing defendant Jason Terrell Taylor moves for an order quashing service of the summons and complaint. Defendant asserts that the summons issued in this case is substantially defective and could not confer jurisdiction upon him because it substantially deviated from the summons issued in this case. Defendant requests that the December 21st, 2023 judgment be set aside as void. Now, put a pin in that, because if you remember, the reason why he's bringing up the December 21st, 2023 judgment is because, no. I just came back over here. I can't see y'all. I'm on a whole nother screen reading the paperwork. I know y'all see me see you seeing me see the paperwork. Yes, special guest, Mr. LA Confidential. Now, back in December of 2023 is when Priscilla moved the case from Illinois to California. And when the case got to California, California ruled in her favor. And so assets like that house and all that money they was funneling was stopped and reversed, and it was to go to her. So now this is what he's bringing up in this court doc, is he's trying to get that stopped and voided out. So we're going to go here. First, defendant contends that the summons and publication did not accurately reflect the title of the court, which is what I was telling you, Santa Monica. All right. It says the summon identifies the court exercising jurisdiction as Santa Monica Court at 725 Main Street, Santa Monica, California. Defendant observes that the court is technically the superior court of the county of Los Angeles, not the Santa Monica courthouse, and that at worst it is in immaterial variation from the title of the court. Okay, the court's address is actually 1725 Main Street is what they're trying to fight. Okay, so it says, second, defendant argues that the summons and publication does not meet section 421.20 A2 requirements, that the names of all parties be stated on the summons. Indeed, the publication printed in the Los Angeles Daily Journal omits defendants JTT Holdings LLC and F12 and Associates LLC as defendants to the action. Okay, that said, defendant fails to show how the publication did not substantially comply with the requirements as to himself rather than the unnamed defendants. The courts have held that even if the service of a summons with an inaccurate name or otherwise properly made, and the person served is aware that he is the person named as the defendant in the erroneous manner, that jurisdiction is still obtained over that individual. That's what they're saying. Okay. All right. The court thus obtained jurisdiction over the defendant, even if the publication did not confer jurisdiction as to the unnamed defendant. So even though, okay, there's still jurisdiction over him. All right. So third, the defendant contends that the publication did not accurately reflect the name, address, and telephone numbers of the plaintiff's attorney. Oh, yeah, that's right. I forgot about that part. It had the wrong attorney on it. All right, so that was the other portion of what it was. Now, child, when we get on down here, you see what this says in big bold letters. This is the end of the ruling. Accordingly, the motion is denied in its entirety. The motion to quash service of summons filed by Jason Terrell Taylor on 1/3/2025 is denied. And denied. All of this was a trick. Okay, it was a nice try, but you just wasted the court's time, your lawyer's time. I mean, it must be nice to just have money to be able to throw away when you got people coming after you for multi-millions of dollars. Because remember, her lawsuit is not $1 million lawsuit. It was a $7 million lawsuit, okay? So now that was a nice try. But nah, the court said nah. And I don't blame them because at the end of the day, bro. Okay, let me go here. Oh, no, it doesn't give you any other breakdown. It just tells you what it was. My thing is this. When all of this was going on in the case, when it first went over there to the LA courts and all of that stuff in 2021, and when the case was still going on in 2022, why didn't you then go and serve this dismissal? You wait till now after everything is done and settled and she's actively pursuing you to actually go ahead and continue with this suit. Anyway, moving right along to the coup de grace of things. Here we go. Aside from being sued by Priscilla Rainey, y'all see the court doc up on the screen. It looks like Wack and the Game are caught up in a lawsuit together. Now, if you remember one little statements that Wack made when people were questioning him about the transcript that I read on him, he said, "My name ain't in no lawsuits. She's suing the Game." Well, this company right here, this company, this is Tour Squad Party, I'm going to assume, Ltd. And they're an Australian-based limited liability company. And they are suing Fifth Amendment Entertainment, a California corporation. Cash Jones, an individual. Jason Taylor, aka The Game, an individual. And those 1 through 10, inclusively. Your name on another lawsuit, bruh. And this time your name ain't at the bottom of the lawsuit, bruh. This time your name is number 2 on this case. But that's gonna change. Don't worry, I'm gonna take you there. Not like Maya, but I'm gonna take you there. Y'all ready to hear about this? Let me change screens for y'all real quick because I have a whole nother screen that I'm about to show y'all. Let me go ahead and pull this window up. Let me pull the window up. It's the same court doc, but I have important parts that are already highlighted off for y'all. All right, here we go. Let's rock and roll. And let me get my glasses on. Oh, hold on 1 second, guys. Okay. I had to make sure I had everything lined up. Let me go ahead and get these glasses on for y'all. Because we're going to dive into this international case. And I'd love to see how he's going to wiggle his way up out of this. Okay, so this court document is an enforcement of action filed in Los Angeles, California, in the Los Angeles Superior Court by Tour Squad Party Ltd, like I said, an Australian company against Fifth Amendment Entertainment, Cash Jones, and Jason Taylor, The Game. And the purpose for this filing was to enforce a foreign judgment that was previously issued by a federal court in Australia in favor of them. Now, if you go ahead and you take a little gander at things, we're going to scroll on down to where it says that. All right. Right here in the court document where it is highlighted, it says first responded Fifth Amendment Entertainment, second responded Cash Jones, and third responded Jason Terrell Taylor, aka The Game. And Taylor both Jones and Taylor are both California residents. Okay. Agreement entered into in Australia in 2017. Now let's get to that. Let's get to that. In 2017, the Game and his company signed a contract, okay, to perform 7 concerts in Australia and New Zealand, okay? And Tour Squad paid them up front, covering their travel, their accommodations, and promotional costs. And the Game never showed up. He never showed up. He never showed up. All right? And they never refunded him the money either. Okay, so this part right here is saying agreement entered into in Australia in 2017 between applicant, a promoter, and a facilitator for the music entertainment, and Cash Jones individually and on behalf of Fifth Amendment and JC okay, the Game. And he was to perform, this is where it says in the court doc what I just said, okay? And it was established by the Australian federal court that Cash Jones took on personal liability for the obligations of Fifth Amendment Entertainment, Inc. and Taylor upon signing the agreement, okay? Applicant advanced money to Fifth Amendment and Taylor, who failed to perform as required by the contract. So y'all know I am not just talking out of my whoop-whoop. I am stating facts, honey. These are facts of the case, all right? So in 2021, the federal court in Australia had ruled in the favor of Tour Squad. And guess what? They ordered the Game and his team to pay back the money, honey. Where's that, honey? I'm about to show you. But before we get there, I got ahead of myself. I'm sorry. I got excited. When they looked into Fifth Amendment, Inc., it says in the court doc in red right here, Fifth Amendment, Inc., a California corporation, was suspended by California Franchise Board on May 3rd of 2010 and to date has not been revived. Now, pause, big old New York pause right there, because I told y'all that that company was not a functioning company. I told y'all Fifth Amendment was not up and operating, and here you have it. And for anybody who wants to say, oh, that's bullshit, let me go back to the top of this in case y'all missed it. This was originally filed at 7/25/2023, and guess what? This was from yesterday. They were in court yesterday. I'm going to get there and I'm going to show y'all, okay? So if in 2023 it was not up and functioning, and then when we get over here to when I told y'all, when we first started going through the Game stuff, that Fifth Amendment was not an active company, I'll do y'all one better before this is over, because I like to cross all my T's and dot my I's, all right? So based off of what I just said right here, it says the judgment was entered on May 25th, 2021 in the federal courts of Australia against the 3 respondents, and the amount was $478,119.73. Okay, application was ordered paid by respondents to applicant in the amount of $20,000. Now, this is where it gets a little tricky because they start breaking this stuff down. All right, so let me go ahead and let me break this down for y'all. Okay, so you have the $478,119.73. Then you have $74,580.08 for a prejudgment interest, and then you've got $122,700 for legal fees and additional costs, for a total of $789,070.28 is what all of that totals up to, and anywhere you get that from, right here. Now, this is all in Australian currency, but when you convert that over to US, it is $541,537.40. That's what he owed these people for breaching the contract. So now, Tour Squad, as of right now, let me take y'all over to that little court document over there. Let me take y'all to the next court document over here. All right. It's time to switch court docs. Hold on. Give me a moment. Because now, wait a minute. Let me make sure that I've covered everything on that court doc. Hold on. Okay, so this was the notice of the filing that they sent, because they did notify Wack that he had a case, okay? They did notify that there was a case. Here is their Exhibit A, which is a notice of filing. Okay, and this was dated 7/22/2020. Important information. All right. Federal Courts of Australia. This is Tor Squad. And then he names everybody that he just named in that case. The date on this is July 2020. Okay, July 22nd, 2020. This is everything that was sent to him. All right. The applicant on the application that on or about 1:26 p.m. on May 18th, 2020, the application's previous selectors on record, McCormick's lawyers. So that's who Wack and them had on file as their lawyer for this particular situation. And here's his receipt. He sent this express delivery parcel, the FedEx. They sent it through FedEx, okay, because he was trying to get this information to him. And this man has used FedEx. He's used UPS. He has tried to get in contact with them. Well, guess what, y'all? Let's go back to the previous setup that we had. Let's go back there. Boom, boom. And let's go to this document. They've made their way to the Superior Court of California. They have made their way to the Superior Court of California. So Tor Squad is now seeking to enforce the Australian judgment, okay, over here in the U.S. And since the Game and Wack are U.S. citizens, they needed a California court to recognize the judgment so that they could legally seize assets. Oh, I wish I had my boom. I think I still have this. Do I still have this? Nope. I don't have none of that. All right, I'll get my sounds back. Okay, so now that it's made its way here, if the Game, well, let me say it in the order. If Wack and the Game do not pay up to Tor Squad, they can freeze their bank accounts, they can seize assets, they can garnish wages from future incomes, okay? Now, in this document right here, the court reviewed everything. You want to know what the courts had to say? Because I'm going to tell you what the courts had to say. This hearing was about whether the court should enter a default judgment because the Game, Fifth Amendment, and Cash Jones failed to respond. And guess what? Let me not jump the gun. For the defendant, there was no appearance. Nobody showed up to court on their behalf. They ain't sent no lawyer in the courthouse for this. So they didn't respond and they didn't appear. And since they didn't show up, the court moved forward with the plaintiff's request, which was for a default judgment. Okay. Now, what happened in this proceeding? The judge reviewed all submitted documents, including the original documents from the Australian courts, and its enforcement request to the U.S. because the federal courts over there in Australia sent the request here, and the judge ruled in favor of the plaintiff, which means that he kind of like officially won. But what's going to happen now is they have to go back to court on February 28th this month, okay? And the judge will review the final judgment without another hearing, as the defendants did not contest it. Right here, non-appearance case review. Submission of proposed judgment is scheduled for 2/8/2025. And notice, the notice to them about this is deemed waived. So all of this that he been out here talking about, my name ain't on no case. Y'all took them people money over there in Australia and did not go and perform the way that y'all was supposed to perform. They didn't bother to reschedule. They didn't bother to say jack, squat, diddly, nothing at all. So them people did what they were supposed to do, and they went on to their federal court system overseas, and they got their judgment and then brought it over here to the U.S. soil. They out there in California going to court. Now, let me be very clear. This is not a criminal case. This is a civil matter. But they coming for the manyan, y'all. King Koros on the yard paper. I don't know what you mean by that. LA, Las Vegas Freedom News. Salute to you. Can you repeat that? She said, oh, shoot, disregard my message. I responded to the wrong app. The first delivery place is closed. Oh, that's what you was talking about. Okay, my bad. So the game a whole scammer. Now, I don't know if the game is in on a plot and plan and a play, because y'all got to remember, go back to them transcripts and listen to what Wack had to say. Wack said that he sets this stuff up and the game got to go perform. That's what he says. Now, these people coming for him, he ain't showed up in court. So now on the 28th, Henny going to be in the court. I was watching what happened next, because they, child, them Australian boys was not playing. They said, give me the loot. I'm a bad boy. Okay, they played chess, not checkers all day, every day. But anyway, y'all, this was a Court Doc Roundup with your girl, Henny. I'm glad that y'all have tapped in with your girl. I have more stuff coming, more BMF content, and all of that is on the way, plus some Wendy Williams. So, y'all, I am back, and I'll see y'all in the next video. Peace, y'all. Run it up, and don't forget to smack that like button on your way out. Peace.